I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Thursday, July 11th, 2024. The time is 10:26 in the morning. We are having this hearing in room 412 of the Johnny Wilson Building. The subject of this hearing is consideration of two bills. Bill 25-654 entitled Protecting Adjacent and Adjoining Property Owners from Construction Damage Amendment Act of 2024. This bill was introduced at the request of the mayor on January 4th of this year. And the stated purpose of this bill is to amend the Construction Codes Approval and Amendments Act of 1986, which requires insurance coverage for certain building permits by adding three types of permits to the current scope of the requirement. And those three types are: first, alteration and repair permits pursuant to which the applicant will be engaging in underpinning or related construction activity. Second, foundation permits. And third, new building permits. The second bill that's considered today is Bill 25-737, entitled the General Contractor Licensing Amendment Act of 2024. This bill was introduced by me together with Councilmembers Pinto and Louis George on March 1st of this year. And the stated purpose of this bill is to establish a scope of practice for residential and commercial general contractors, to establish eligibility criteria for the licensure of residential and commercial general contractors, and to create a board of residential commercial contractors to oversee the licensing process for general contractors operating in the district. Both of these bills correlate to the concern that we've had for quite some time about minimizing illegal construction and ensuring that when construction does occur, that it is conforming to the code and is of a quality that is not later subject to concern, problems, litigation, damage, and so forth. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Thursday, July 25th, 2024. It's not that the council is going to act or the committee is going to act on this on July 26th. In fact, the earliest we would be able to act on these bills would be the end of September, early October. However, we have to have a record, and if anyone wishes to submit comments or elaborate on their comments and have them included in the record, 2 weeks from today, the record closes. We have 5 individuals who have signed up to testify before we get to the government, and I am going to call them. If they're all in the room, which would be wonderful and beautiful, then I'll probably stop at 4 because there are only 4 seats there. Robert Vincent Branham, Thomas Glassick, who's Executive Director of the District of Columbia Insurance Federation, Mimi Nurani, David Maloff, Ike Casey, who is Executive Director of the American Subcontractors Association of Metropolitan Washington. Mr. Glassick, you can come forward. Don't be bashful. The others, I think, or some of the others who are participating virtually. Oh, I see. Okay. But you get a gold star for being here in person. I'm not sure what happens with these gold stars, but you get a gold star. Before you begin, let me recognize my colleague, Councilmember Anita Bonds, in case she has an opening statement. Councilmember Bonds?
Thank you very much. The statement that I would like to put on the record is one, a great appreciation for these bills coming forward and being examined. Over the years in the community, this is one of the issues, particularly in neighborhoods where we face with continuous construction and reconstruction, and it is an opportunity for us to hear how we might address some of the issues. I know that particularly it is of concern for our seniors community. They've lived long in neighborhoods, and they are most pressed by not having the resources to make the necessary repairs once their property is damaged. So I'm excited to hear how we're going to move forward on this. And thank you very much for this opportunity to examine these pieces of legislation.
Thank you, Councilmember. So I called Robert Vincent Branham. He is not here in person or virtual. So let's turn to Mr. Glassick.
Thank you, Mr. Chairman. My name is Tom Glassick, and I'm the Executive Director of the DC Insurance Federation. And we are here only about the adjacent and adjoining insurance requirements. And I'm going to try for a second gold star. And I'm going to keep this short. We have absolutely no problems with the amendments. We've been working collaboratively with the DOB and DISB to get the 2022 legislation implemented. And I just wanted to be here to be supportive of DOB and also to answer any questions you have, but we have no issues with from the insurance perspective.
Great, thank you. I don't give out gold stars based on the content of the testimony.
Well, no,
although I
keep it
may
short.
take that under consideration.
Okay.
I may come back to you with a question though. Ms. Noorani?
Thank you, Chairman and Council, for having me here today. And thank you for recognizing the importance of the significant risks faced by neighboring properties. I wanted to add a few thoughts. One is to amend the text of this bill to note adjoining property owners as the named insured of the policy. And this would allow an adjoining property owner to make a direct claim as a primary beneficiary, which would greatly ease the process. And if the APO, adjoining property owner, is not specifically named, then we depend on the goodwill of the developer to obtain the compensation from their insurance, and which is kind of what's already in place if they have insurance. And then the developer likely has little interest in doing so, as this would trigger a rate increase. So it would make it easier if we could claim that way. Of course, and I also want to note that homeowners policies do not cover claims for adjacent property damage. The second thing I did want to say is we really want to emphasize prevention, that these types of damages, we really want to start avoiding them at the permit review stage, and if not caught there, that they're mitigated during permit oversight. I speak for many when I urge DC Council to work with DOB and to accelerate their welcome efforts that I feel that the current leadership has to reform and strengthen permit review, oversight, and enforcement. Because even assuming readily available liability coverage, homeowners should not be saddled with this disruption, alternate housing needs, and the associated costs of these often preventable damages. I know council's tired of hearing of it. I know from constituents at these meetings, I know the courts don't want to hear it. And again, especially in permit review, if we could bolster that, these seniors the stuff wouldn't get to the next level, and also the enforcement, because it's hard for anybody to know what's going on if they're not familiar with it. And lastly, even though I'm all for policies that reject and eject bad actor builders in the city, I also want to ensure that we're taking care of the good construction practices and good tradespeople, because we do, like DOB, we want a safe industry and we want a thriving industry. Thank you.
Thank you, Ms. Noorani. I don't have a copy of your statement. Would you please submit it?
Yes, I will. Thank you.
Okay, great. David Maloff? You are muted.
Chairman Mendelson, Councilmember Bonds, thank you for allowing me to speak today. I am David Maloff, a 41-year resident of the district and past president of the DC Federation of Citizens Associations. At that time, an umbrella group of over 24 citizens, civic, and neighborhood associations around the district. Thank you for allowing me again. I've been here many times. I stand by all my past testimony on what needs to be repaired at DOB, but specifically regarding this bill on protecting adjacent property owners from dangerous Section 3307 construction. The title is good, but it lacks specificity and force. I provided you today with specific edits via Microsoft Track changes, very simple, but 4 things are, in my mind, absolutely required to make this bill substantive and protective. The numbers involved here are staggering, over easily 5,000 residences per ward. That's about 40,000 for the city minimum, based on my back of the envelope calculations, applying a minimum on average for a row house type party wall building of say $1 million. You're up to $40 billion in people's life savings here. And I can get those numbers higher, and we can talk about how those are calculated if you like. The 4 changes that are necessary in this bill are, first, to make it clear, as Ms. Neroni said, that APOs must be named as insureds on the policy. It's like adding a driver. And second, it must be a precondition to permit issuance that proof of insurance and addition of the APOs on either side insured be provided and approved by DOB. This is consistent with Mr. Hanlon's testimony today that's already written and on the internet. Third, reinstate all DCRA neighbor notification program rights and rules that were in force prior to the birth of DOB on October 20, 2022. This is not Mr. Hanlon's problem, but this is his opportunity to fix it. At that time in October, all of the pre-permitting rights of APOs were ripped away, were basically completely eviscerated and disappeared on the website. I request that all of those rules, forms, procedures that were a build out of DC code 3307, 106, and 112 be reinstated for the time being. And fourth, although the mayor's letter and Mr. Hanlon's testimony states there will be a rulemaking, this bill, the first one for protecting property owners, doesn't state that. Specifically authorize a rulemaking for DOB to address this bill, filling it out, and also to address the DCRA neighbor notification program procedures and policies that have been reinstated. And if DOB wants to then modify them, have open presentation by members of the public. I've got 4 other key sentences, which I don't want to really trouble you with today, other than the fact that this is kind of an after the fact, after the milk is spilled bill, and those changes I recommend are important. But what's most important, Mr. Hanlon, in my first meeting with him 2.5 months ago, stated communication between all parties is key. That means the neighbor notification program as it was, that was robust, that's not almost flimsy as it exists today for DOB, needs to be reinstated. Mr. Mendelson, if you look at the current forms today, you'll end up shaking your head, I think, and we can sit down for 10 minutes and walk through them. Nobody even has to sign the forms. So we've gone backwards, not forward, and we have people's life savings at risk who cannot afford to wake up one morning and find out that there's water in the basement and that the walls are cracked and that the house may be almost unlivable. Thank you very much. I'm available for further clarification.
Thank you, Mr. Malouf. Ike Casey. Mr. Casey?
Sorry, I didn't realize I was in control. I appreciate your time, Mr. Chairman. I'm Ike Casey, the Executive Director of the American Subcontractors Association of Metro Washington. We're also a part of the Alliance for Construction Excellence. That's a group of 7 subcontractor, specialty contractor groups with about 1,000 employers and about 50,000 employees. We're here primarily for the commercial construction, and we support this legislation, both bills. That's a little unusual for a business group to say we support legislation, but we do support this and appreciate the efforts of yours, Mr. Chairman, and also Brian Hanlon. The issue of underpinning came to my attention by one of my members, Andy Steele with Steele Foundation. They've been a member, or they've been doing work in the district since 1968. And he often comes across situations, both commercial and residential, where the underpinning is just not acceptable. It doesn't work. So somebody's going to suffer. And we don't want to see that happen.
Thank you.
The subcontractors are important to this because they're the ones that are really doing the work. They're the ones that are in there making sure that the work is done properly. And this work is sophisticated. It's not something that any homeowner can do, or you can go down on the corner and find a couple of guys to come in and do shoring and underpinning. And so that's one of the main reasons we support this bill. It's important that we have properly trained people doing the work, and also assuring that they've got the background and insurance. The insurance is important too, that the homeowner or the business owner, the developer, the people that own the building are protected. We think that these bills are good because they require permits for new construction as well as the construction of the underpinning. The underpinning is vitally important, but the new construction is important too. We think it's important to require the insurance so that the building owners are protected. As far as the licensing bill, we have some experience with the Virginia licensing bill. It seems to be working pretty well. In DC, as I understand it, you come in and you fill out a form and you pay a fee and you get licensed. And there needs to be more to the licensing than that. And I believe this legislation will put that in motion. We do recommend that you pass this legislation. We also ask that you invest in enforcement, because this legislation won't be any good if there's not some way to enforce it. So as the time moves forwards, please be sure that the Department of Building has the funds necessary to enforce these bills. And then I would humbly request that you consider a subcontractor on this Board of Residential and Commercial Contractors. The lawyers in the room will say, well, you don't have a privity of contract. We hear that daily here at ASA. But the subcontractors are doing the work, and they have a lot to add when it comes to this type of issue. Thank you for your time.
Thank you, Mr. Casey. And I do have a copy of your statement. That's very helpful. So I have a few questions. Let me see. A couple of the witnesses testified that the adjacent property owners, APOs, that's a new term for me, must be named insureds on the policy. Mr. Glassick, do you see an issue with that?
I would need to explore, but you have to have an insurable interest. And normally an insurable interest is not someone besides yourself. We had this issue with life insurance back 20 years ago where companies were buying life insurance policies for their employees and not even letting the employees know. So I do not know if there is an insurable interest in an adjoining property. And I certainly don't think it exists right now. So I would need to spend some time with that. So that might be a legal hurdle in the way of that.
Putting that aside, which sounds pretty important, would you otherwise see an issue with this? I would think not.
I don't
Insurance
think-
companies like to do insurance.
I mean, other than the complexity of, I can't speak for the contractors and subcontractors, but to go and get the names of the owners of the adjacent properties and getting that separately in an insurance policy is just another step. And the permitting process is detailed for a reason, but no, we wouldn't have any problem with that. We always have to, as you're adding adding coverage, you're going to add premium. And if you add premium, then that's going to impact the building costs in the District of Columbia. I'm not opposed to the idea, but we do need to remember that as we add things that have to be insured, we add someone who has to pay for the insurance.
Fair enough. You'll look though at this issue of whether it's even possible to require that the APO be named insured.
Yes.
Thank you. Mr. Casey, do you see any issue with it?
I really do not. As Mr. Maloff stated, anything that impacts the cost of construction is passed on to the client. And so, I mean, that has to be taken into consideration. But as subcontractors and I would say general contractors, I don't think there'd be an issue with it.
Mr. Maloff, I don't want a long answer here. That's always a poor way to start a question, but you have brought up in a number of hearings this issue of the neighbor notification. And if I remember correctly, it's because you were a victim of non-notification and subsequent issues. Could you very, very briefly describe what happened?
Well, to the contrary, in August 2022, I received 3 certified letters that were actually very officious, quite threatening, even mentioned the possibility of a court order if I didn't agree to access and so forth, which absolutely freaked out my family. And for the last year and a half, we've been struggling through following all of the rules and regulations of that neighbor notification program. In the end, it ended up being a good warning signal, and we were entitled to answers to questions. We never got those. So the neighbor notification program is pre-permitting. It was a set of rights that allowed people to not just sit in their homes and cower. As it's structured now, basically you get the letter, nobody signs it, and I guess that's a hint to go buy a hard hat and earphones. So we need to put that back so that there is pre-permitting dialogue between the property owner. Some of these projects are close to being almost unnatural acts. Now, I'm not a structural engineer, but this underpinning thing is extremely dangerous on a residential basis. And DCRA and DOB have a sacrosanct bulletin 001 from 2015. It's not in the code, sir, but it is treated as the Rosetta Stone that everyone must follow. So there are things at DOB that are not written in the code that are build-outs of the code. And this neighbor notification program was a part of it. It needs to be reinstated in full, and then we can talk about what modifications to make. I think you can put time limits on coming to resolution and dialogue, and that's not in the old neighbor notification program. I'm fine with that, but you can't eviscerate rights and wake up one morning and hear the sound of dental picks under your home and wondering how deep people are digging, what the authorized skills are, materials, what's going to be left under my home. And with pop-up and penthouses, it's the same thing. What's the load going onto the party wall? And I think Section 106 requires that calculations be provided. I shouldn't have to review those after the fact. I should have my engineers or just look at it with some reassurance that the calculations have been done, that the materials have been specified, and that the skills exist. So this thing is currently, I'll say it, bass-ackwards in the way it should be structured, and the insurance is nice, but it's after the milk has already been spilled. We got to put it back in, sir.
Let me ask Ms. Noorani, was this an issue for you as well?
I was under the old neighbor notification program, and I only realized recently these drastic changes that Dave is talking about. And I didn't get my questions answered. And but I will say that again, the new neighbor notification is a lot different, and you don't get notified until after they've already got their permit. And then you have right now 10 days to send in a technical objection, which, you know, you're just spinning. You don't even know probably what a structural engineer is to review it or how to find one.
Right.
And then you don't have, you know, there's no guarantee that the information that the structural engineer needs, such as calculations to understand they're doing it right, are there. And then right now, there's no requirement for DOB to have to respond unless they deem it worthy, which is very vague. And lastly, 10 days is a lot can get done in 10 days. And if you don't get a response for 20 days, you could almost be underpinned by then if they were, and that's just, it's just not much time. And in my case, they didn't get all the right permits. They didn't do the proper bracing. So there was all cross-structural supports removed and they were underpinning. But I didn't even know, I was just trying to figure out what was going on. And I took 5 months before I got a structural engineer. And that's when I realized how bad things were. But yeah, I'm sorry, I don't want to dither on, but yes, it's changed drastically. I believe with the inception of DOB.
Thank you. Give me just a second. I do not have any other questions for any of you. Thank you for your testimony. At least one of you owes me a statement. And again, thank you all. Oh, no, don't go anywhere yet. Councilmember Bonds.
Thank you. Thank you very much, Chairman. I do have a few questions. I really want to examine a little more two issues. One, this insurable interest requirement. And so, Mr. Glassy, could you speak a little more definitive about that? I believe you mentioned that it would require the names of the owners of adjacent properties. Is that correct?
Yes, ma'am. The way I understand the proposal, I haven't seen what's actually been proposed. But the way I understand, they're talking about it as you would add the adjacent adjoining property owner as a named insured. So kind of the analogy to auto works just fine. If you add another insured, you give that person rights or that property owner rights under the policy. And I just don't know if it's legally possible. I'm not opposed to the idea, or not that I have an opinion, but it doesn't happen anyplace else.
Okay, doesn't happen anyplace else.
And I'm sorry, ma'am.
Oh, and so, well, tell me, from the insurance industry's perspective, how do you handle these situations where there are row houses or attached homes, and there is structural damage? How is that handled?
So, at present, contractors go and get a CGL, which is a current commercial general liability policy, and the CGL policy, it depends on how big the construction project is. Sometimes it's one event for $1 million, $2 million per year, those sorts of things. The CGL policy, we're fairly comfortable, and I've been working a lot with the DOB, and we're fairly comfortable if someone's, goes and gets a CGL policy, that the current CGL structure would handle this. I mean, it's liability for that construction project, and if there's damages outside of that construction project that is related to the project, then it's insured already. But like I said, we've been spending a lot of time with the DOB getting the building trades and the insurance trades using the same language. There we go.
All right, so in using the same language, I think you're telling me that the property that is being repaired or constructed is what is insured, correct?
Yes, but there is coverage for things outside of it. Like, if you're building a house and someone drops a brick on someone's head while they're walking by,
Right.
that would cover. I'm sorry that's awfully blunt, but so it doesn't just cover the boundary of that policy.
Okay, but it covers the boundary of that property exclusively, correct?
If there's damage to, if the construction project, so this is liability, not property damage. So if the construction or the general contractor is liable, i.e. they did something to cause damage off of the property, that's also insured.
All right, so if it damages adjacent or adjoining property, it is already covered?
We believe the existing CGL policy structures should handle this. The questions are really more about limit as opposed to, because you know what properties cost in the District of Columbia. So if there's a catastrophic loss at the primary policy, and I mean at the permitted property, and the limits, so that 1 million lowest threshold up to whatever, if there is a catastrophic loss and the limits are used up, there's no more insurance for anyone outside.
Okay,
So
I
that's
got
something, yeah, okay.
Yeah.
So
I
it's,
hear you on that. So in the existing policy, there is a way to add a category of if there is damage or when there is damage to adjacent or adjoining property, we could include perhaps an amount, that would be paid out to the owner of the adjacent property without having to name the individual. Is that possible?
that I believe, ma'am, already exists. It's just that
All
question,
right.
are there enough limits? Yeah.
Okay. So then we might be talking about increasing the limits. And then the cost of the insurance would be borne by the construction contractor, right?
Yes,
Not
ma'am.
by the owner of the adjacent
No,
or
certainly not
adjoining.
by not by the
Okay.
owner of the adjacent or adjoining. Now,
Okay.
the adjacent or adjoining properties, if they have homeowners insurance, which I hope they do, their own homeowners insurance policies should respond to some of these things too, but that's not fair.
No,
That's
No,
not
it
ultimately
isn't.
fair.
It isn't. What I'm hearing this morning is that's not an issue of fairness. And so I just wanted you to give us a little more detail from the perspective of, how your policies are written and what a homeowner might anticipate. I really appreciate you going into detail. Thank you very much. Mr. Chairman, I had one other thought. Will there be another round or what? No? Okay,
No, there will not be another round, but we didn't set a clock on you, so
okay,
you can
okay.
keep going until sunset or I cut you off.
No, it will not take that long. I did want to ask a little bit about this this rulemaking, and more importantly about the precondition of the when a license or permit is granted. I wanted to hear a little more from Mr. Mello about how you see this process working, because it seems to me, and Ms. Nicole, I remember when I had my neighbor's property was being improved, I'll say improved, I certainly had to sign off on it. And I think that process doesn't exist anymore. It's pretty much what you're saying. That helped me to know what was going to happen before it happened, so to speak. And so I think your concerns are that we don't do it that way anymore. And that leaves the owners of properties that are adjacent or abutting these projects in a real fix.
Councilmember Bonds, regarding the adding of insureds, I wrote a very careful comment in the track changes that I submitted in my testimony. Rather than get into that here, under the comment number 1, those words are carefully chosen. I think that'll help with my point of view on that. Regarding the old program, you got the letter. They'd ask you to sign off on entering the property and this and that. And you had 30 days to hire an engineer or read through the plans that were supposedly online and then make comments. And then you would receive a response back, a detailed resolution report in one package before a permit was cut. That's all been changed, eliminated in toto. You now receive a letter that nobody signs. They still want you to sign it. that you will allow the project to proceed, although you may not know exactly who was sending it by certified mail. And you have no right of comment prior to permitting. Supposedly the plans are online, but what DOB does is they dump all the detail in the day that the permit is issued. So there might be a few things online, but not everything. And then you have 10 days to figure out which way's up, to hire an engineer and figure out if you have any complaints while the dangerous construction is already proceeding in earnest. That
Okay,
is
Mr.
a
Miller,
process.
I appreciate hearing the details, but I want to know, is that currently in law, what you just described?
What
Or
is
is that
currently
just
in law is
Greg?
neighborhoodification, small n. And DOB built it out, just like they built out the underpinning details over the years, and that was ripped away in October 2022. That was a very settled program, very detailed procedures. That needs to be put back into place, just like the underpinning
All
rules
right.
exist.
It sounds like we need to think about how we legislate some of this. So I appreciate it. Thank you very much, Chairman, for
Thank you.
giving me the opportunity to ask a few questions.
Thank you.
Thank
Mhm.
you, Councilmember Bonds. So, Mr. Glassick, you said something that got some of the witnesses all jumping up and down. And it was when you said that the adjacent property owner, if they have insurance, which they should help with regard to damages. You remember saying that?
Yeah,
So,
I said that. I did not encourage that as an approach. I'm saying that if your home is damaged by someone, like if someone drives a car into your home, your homeowner's insurance will respond. But that's a claim on your homeowner's insurance, and that's an impact on you going forward for premiums. And I
Absolutely
am
not.
100% certain, but
so you think, because so I have standard, I think it's called fire and casualty for my house. And so that might offer some coverage.
yes.
But so let me ask you this. Let me see. Now, and I remember what you said before, that there may not be an insurable interest, but again, putting that aside, and I realize that's an important matter, so I don't mean to minimize it by saying putting that aside, but just for purposes of this. The adjacent property owner is still in an adversarial position vis-a-vis a developer, let's say the house next door, or we're talking about commercial property, the property owner next door.
Question.
The adversarial position vis-a-vis a developer and the developer's insurance company in efforts to obtain compensation, as opposed to an additional claimant on a policy by virtue of being a named insured. Absent this, there seems to be some belief that courts in other jurisdictions have refused to enforce this type of insurance claim absent a clear statutory requirement. In brief, without a statutory requirement, making clear the legislature's intent that the adjacent property owner be a direct beneficiary of the policy, it's possible that the courts will find that the adjacent property owner has no status to assert a claim to this coverage because the contract enabling the work is between the developer and the contractor.
The last 5 words I missed, you were talking a little fast.
The courts may find that the adjacent property owner has no status to assert a claim because the contract enabling the work is between the developer and the contractor. So I guess the way I'm hearing this is that the developer decides to redevelop the house next to mine. It's a row house. Underpins does substantial damage to my house. So I'm a named insured, which may or may not be possible, but let's say I'm a named insured, then I'm a beneficiary of the policy. I'm not a named insured because we don't require that. Then when I'm damaged, I have to assert a claim against the developer next door. The developer's got insurance, but the developer may defend, the insurance company may defend and say, Mendelson, tough luck.
Well, I mean, you would have to show liability. I could see where the developer would say, I didn't, this is a factual matter that you'd have to establish liability. I would think a responsible contractor in District of Columbia would acknowledge damage and everything else, but I know there's a lot of unresponsible. I know
Yes.
but insurance companies are not trying to not pay these things. It's just they have to get to them. And yeah, I didn't mention when we're talking about insurable interest, one of the reasons why we have insurable interest issues are why we have insurable interest requirements is the possibility of fraud. Like, what if you owned the adjacent or adjoining property, and you caused damage, you claim on that insurance policy, they wouldn't necessarily know. I mean, it's a slippery slope. And like I said to Ms. Spons, it just doesn't exist anywhere else. So we're talking hypotheticals.
Mr.
Okay.
Matheson, if I may.
Briefly.
Yes, regarding the homeowner's policy, the average homeowner who's got cracked walls because of construction next door is up the creek without a paddle. I've had State Farm for 30 years. They're a superb company. My agent said absolutely positively, I am not covered for construction damage caused on the party wall, except in the event of total collapse of my house. And that can be found easily in, I think, most of these policies. So yes, they'll cover it if the roof falls in. But other than that, I have to go file a claim. The insurance company, if I'm not a member of part of the policy, I end up at Superior Court. We've got to stop having innocent residents flung, gnashing and wailing their teeth into Superior Court. That's the essence of this issue here. And if the construction should not proceed because it's highly dangerous with the wrong people, then so be it. It's not cost effective. We should not shift the risk and cost onto the unwitting, longtime resident loyal to the city. Thank you.
All right, so Mr. Glassick, you'll look at this and get back to us.
Yes,
Yeah.
Mr. Chairman.
That would be very, very helpful. I have no further questions for you all. Councilmember Bonds, you good for the moment?
Yes, thank you.
All right, so thank you all for your testimony. Mr. Glassick, we didn't have a statement from you either, but you'll follow up. with-
Yes.
Okay, great.
Thank you.
Thank you all. Thank you for your testimony. We'll turn now to the government. And the government consists of Bryant Hanlon, who's Director of the Department of Buildings, and Tiffany Crow, who's Director of the Department of Licensing and Consumer Protection. Please don't ask. Okay, do you want me to swear you in? I haven't sworn witnesses in since I had judiciary. In fact, I'd rather not talk about it because the rules require it and I don't want to do it. Now I'm in trouble. But I did. Recess starts in 2 days. I'm ready to let loose. All right, which one of you is going to start?
Oh, sure. I'll start.
Good morning.
Good morning. Good morning, Chairperson Mendelson, committee members, and staff. I am Tiffany Crow, Director of the Department of Licensing and Consumer Protection. I'm here today to testify regarding B 250737, the General Contractor Licensing Amendment Act of 2024. This bill seeks to establish occupational licensing for residential and commercial contractors and create the Board of Residential and Commercial Contractors. My team and I generally support B 250737. Currently, general contractor businesses are required to obtain a basic business license with a general contractor endorsement. However, in contrast to the other regulated non-health related occupations and professions, general contractors are currently not required to obtain an occupational or professional license to do business in the city. Maryland and Virginia both have occupational licensure requirements, as well as a commission or board for general contractors. Based on conversations with our colleagues at the Department of Buildings and what we see in our consumer protection work, we believe this bill will help fill a gap in our ability to address enforcement related to general contractors. A general contractor must be a skilled professional as they oversee construction sites, manage material deliveries, hire subcontractors to perform work, as well as ensure the safety of a crew and the public, among other duties. The bill requires each residential and commercial contractor to meet certain educational and experiential requirements, reducing the likelihood of incomplete or unsafe construction projects. managed by unqualified individuals. Requiring residential and professional contractors to obtain an occupational license will likely reduce the number of general contractors who lack the proper skills and qualifications to do the work they contract for, further elevate the status of the profession, and allow for reciprocity with nearby jurisdictions. The proposed board model also helps to promote career development and networking for general contractors in our community. We do have a few recommendations and hope to work with the committee to finalize the bill. Along with my testimony, I've submitted a red line of the bill that draws on our experience in licensing non-health related occupations and professions and facilitating non-health related boards and commissions. For example, we recommend consumer representation on the board consistent with the 9 non-health occupational and professional boards, commissions, and programs that we currently administer. Consumer representation will help give a voice to consumers, ensure transparency regarding the board, and provide a unique perspective to those board members who come with technical experience. We also recommend that the bill include a provision to establish a guarantee and education fund. This will enable consumers to obtain reimbursement for harms. It will also provide support for the administration and education of the board, and it mirrors those funds created for other non-health related boards. The Real Estate Commission, Board of Real Estate Appraisers, and the Combat Sports Commission each have similar funds. We also ask the council to further examine the implications of establishing an occupational licensure requirement without changing the existing general contractor business license framework. Currently, DLCP offers general contractor businesses a general contractor basic business license. In fiscal year 24 to date, we've issued about 1,800 general contractor licenses and 367 home improvement contractor license. And I mention both of those because there's sort of a similarity between the people seeking those licenses. And it's currently unclear how an occupational license would align with a general contractor and home improvement contractor basic business license. Our reading of the bill did not clarify whether or not a business license would regulate only the contractor who operates a brick and mortar residential and commercial contracting business or the individual contractor. Further, lines 88 to 95 of the bill provide the eligibility criteria for occupational licensure. We support the council's objective of establishing criteria. We just want to make sure that they're not more stringent than other jurisdictions and allow people of varied experiences to seek licensure in the district. We have specified other updates to the bill in the red line, but want to emphasize that we look forward to working with the committee and our colleagues at the Department of Buildings to finalize. We also have recommendations for how to handle those who are currently licensed, who've paid for their licenses using the existing general contractor structure. And we recommend revising the bill to include a provision that grandfathers existing licensees into the occupational license, and then they address those eligibility requirements at renewal, at the renewal period. This will allow us to track those individuals, but also make sure that they are able to see their original license through. We also want to make sure to note that implementation of this bill will require that we update our systems and website. We'll hire staff, we'll need to have communication plan, and make sure that it aligns with the BEST Act implementation that's underway. I would like to thank you again for allowing me to testify. Your ongoing efforts related to business growth, economic revitalization, and consumer protection are critical to the district. I look forward to working with you further on this and other legislative efforts in the near future. With that, I will turn it over to my colleague, Director Hanlon.
Thank you, Director Crow. Good morning, Chairman Mendelson, Councilmember Bonds, and other council members that may be present and their staff. I am Brian Hanlon, Director of the Department of Buildings, or DOB. I am pleased to appear before you today to discuss 2 proposed bills that DOB supports: the Protecting Adjacent and Adjoining Property Owners from Construction Damage Amendment Act of 2024 and the General Contractor Licensing Amendment Act of 2024. DOB's mission is to protect the safety of residents, businesses, and visitors, and to advance the development of the built environment in the district through permitting, inspections, and code enforcement. We strive to be a national model of customer service and value creation. We are a catalyst for responsible economic development, social diversity, and environmental sustainability, and are essential to a thriving and resilient city. I am confident that through our continued collaboration with the council, the district will pass legislation that helps us to accomplish these goals and move the city forward. I would like to discuss both bills briefly, starting with the Protecting Adjacent and Adjoining Property Owners from Construction Damage Amendment Act of 2024. The goal of this legislation is to ensure financial protection for adjacent and adjoining property owners from damage to their property resulting from construction occurring on a neighboring property. The law requires property owners, contractors, or persons applying for specific types of permits issued by DOB to obtain liability insurance that covers loss or damage to adjacent and adjoining property owners prior to permit issuance. In the lead up to the formulation of this legislation, DOB formed a working group with residents and will continue to work with them to protect people, adjacent and adjoining properties, and the built environment. Stemming from this and DOB's internal conversations, we have provided recommendations in the permanent bill before you today to strengthen the legislation that is currently in place. Specifically, we seek to expand the requirements of the Act to encompass the full range of permit types to cover the ones most likely to involve construction activity that could cause damage to adjacent and adjoining properties. These include alteration and repair permits that comprise underpinning, construction at the party walls, foundation permits, and new building permits. Additionally, DOB issues these permit types quite frequently, making these proposed changes vital to protecting the residents adjacent to or adjoining these permitted projects. These additions would bring the total number of covered permit types to 8, an increase of 4 from the original bill. There are also proposed adjustments to the Act's language regarding the definition of adjacent property and removing the requirement to publish insurance quote requirements from 6 companies in a rulemaking implementing the Act. These recommendations were raised to clarify the breadth of the legislation and to ensure clarity for homeowners and industry professionals. DOB remains committed to working with the insurance industry, builders, residents, and the council to deliver a bill that promotes a safe built environment that protects adjacent and adjoining properties. Ultimately, getting this bill over the finish line will show that the district is serious about ensuring the nation's capital is a safe place to live, work, and play. With this in mind, we urge the council to pass this act as a permanent bill so DOB may initiate a final rulemaking process that incorporates this valuable stakeholder input. DOB is eager to fully implement this important legislation in a manner that best serves the district and its residents. And now I'll move on to the General Contractor Licensing Amendment Act of 2024. This act fills a gap that exists regarding standards for residential and commercial contractors operating in the district. While Maryland and Virginia possess robust requirements for contractor licensure, the district's requirements are somewhat lacking. This proposed legislation would create a board of residential and commercial contractors and establish clear eligibility criteria for the licensure of residential and commercial contractors. The board would issue licenses to qualified residential and commercial contractor applicants to operate in the district, with administrative work handled by the board and the Department of Licensing and Consumer Protection, or DLCP. Our agency will work closely with DLCP's leadership to establish stronger standards for the general contractors who operate in the district. This collaboration will be crucial as we work to craft legislation that ensures district residents can receive high levels of consistency and quality that come with robust licensure requirements. Requiring clear and suitable licensure standards for contractors to operate in the district enhances the industry's legitimacy and helps protect homeowners and business owners from substandard work. This aligns naturally with DOB's goals to maintain a safe built environment in the district. We are in support of this legislation and urge the council to pass it. To conclude, I would like to thank Chairman Mendelson and the other members of the council for the opportunity to testify today. I look forward to continuing to collaborate with your offices on these matters. These bills address deeply important matters, and I trust that when fully enacted, they will serve the district's residents, businesses, and visitors well. And once again, thank you, and I look forward to answering any questions you may have.
Councilmember Bonds, I was just debating whether we're going to do 10-minute rounds. I think I'm going to do an ascending clock for me, so we'll see how much time I take. And then, but I'll try not to take too much time, and then you, and we'll work our way through this. Thank you, each of you, for your testimony. Let me see, on the protecting adjacent and adjoining property owners legislation, Bill 25-654. Mr. Hanlon, you mentioned several things in your testimony. It's page 3 of the copy I have. For instance, covered permit types from 4 to 8. Some other changes. All those are reflected in the bill, or are these some of what you're testifying to would be some changes you are recommending for the bill?
I believe they are changes we are recommending for the bill.
Okay. Okay, I trust that everybody's clear what they are. I got a yes. The, in an average year, how many permits will be impacted by this change?
Thank you, Chairman. We actually were discussing that yesterday. We have to drill into our data to get an accurate number, so we're in the process of getting that, and we'll get it to you.
Estimate, for the moment, an estimate's good.
It could be between, I'm going to say 7,000 to 10,000 permits a year, but I really have to verify that.
All right, so you'll get back to us with an
We-
exact number.
We will. We have to drill in, look at all the permit types that we're recommending, and then just do a crosstab on what that impact is. So I want to make sure my number is accurate for you.
Now, does this, since it's so many permits, does this create a fiscal cost
No,
to you?
no, it's for us operationally, it's relatively smooth. And we're actually in the process of redesigning our project intake and creating a template. And so it will be a fairly streamlined process for us to have permit applications come in and be able to double check.
That would be IT software updates
It's included in that, yes.
that got funded with the budget.
It is included in that. Thank you, sir.
The department issued proposed rules based on the, let me see, the permanent bill, the existing law was DC Law 24-339. And based on that, the department issued proposed rules in March of this year, even though the law was adopted by the council on December 20th, 2022. That's a year and a half ago. Why did it take so long to issue rules for the bill?
Primarily because shortly after I came in May of 23, we recognized that there were several permit types that we felt it was important to include in the bill because they included work, which could impact a neighbor's property. So once we recognized that, rather than push out a bill that didn't include them, we made the decision internally that it would be more prudent to just include those permit types. So we didn't have essentially residents that are vulnerable whose neighbors are doing those types of work. So
That confused me. So the rules that you have are based on DC Law 24-339, the existing law. We have before us a bill that would amend that law. The rules to implement the DC Law 24-339 were issued in March of this year. It's a year and a half after we passed the permanent bill. And my question was, why so long? Or is it because you came to the agency last year?
Well, perhaps that impacted it, but I mean, there's, two layers. And one is, first, we recognize that there were permit types that were not included in the original draft.
That's the reason for the bill before us today.
Right. And then we also continue to receive comments from the industry and from some residents. And so,
And that delayed the rulemaking.
yes.
Okay. At this point, do you think the rulemaking is responsive to all the comments that you've received?
I think that we have another round of rulemaking to make sure that we've got this buttoned up. And we believe that that should not take terribly long. I have every interest in seeing this move forward as quickly as possible.
Can you give me a sense of what kind of comments you've received since issuing the proposed rules?
Well, some of the comments you heard in witness testimony that I think need to be considered and then properly responded to. And I'll ask our senior counsel, Monique, if you have anything that you may want to add to the rulemaking process.
Thank you. Not too much to add, but other than what some of the testimony was here today is similar to what we received as far as comments. And also just trying to questions about coverage amounts and things like that, that we are working through, working with our sister agencies to try to, resolve some of those concerns that were raised as far as coverage and how we come up with coverage amounts. So that's generally the comments that we received.
Generally, the comments have been constructive as opposed to oppositional.
I would say yes, absolutely. I think the comments have generally been, but I think all have been really pointed towards refinements to the proposed bill. And so I have not heard opposition to this.
When we worked on what is now DC Law 24-239, again, the current law, DCBIA requested that we include language in the law requiring that quotes from 6 insurance companies be published in the notice of rulemaking. The rationale per the amendment we moved at second reading stated that this would, quote, ensure that the rates established pursuant to rulemaking are not inconsistent with current practices in the construction industry, unquote. You are now asking us to remove that requirement. Why?
Well, first of all, right now, there's only one company that has crafted the type of coverage that is outlined in this bill. However, as Mr. Glassick stated earlier, we believe that the standard CGL coverage or commercial general liability, which all contractors are required to have, is actually sufficiently malleable to provide for the expanded coverage that this bill envisions.
That's the existing, what did you call it again?
Commercial general liability. CGL is the acronym.
How would council approval of this bill before us 25-654 impact the current rulemaking process?
I want to make sure I'm understanding your question, Chairman. I'm
So
sorry.
we're going to amend the law. You've got rules. So when we adopt this, is that going to require some new rulemaking?
Oh, well, yeah, yes, absolutely. Yes, Chairman. Once the permanent legislation goes into effect, we'll be able to go through our rulemaking process. And as I said earlier, we will work to do that as expeditiously as possible.
Is that what you referred to earlier as buttoning this up?
Yeah, that's my term.
What is your view on this issue that you heard from previous witnesses about naming, having adjacent property owners named as insured, as named insureds on these policies?
Well, first of all, we're glad to continue to confer with the insurance industry on this, with Mr. Glassick, with DISB. We believe that if the property itself is covered, that is sufficient. However, we're willing to continue dialoguing on this to make sure that we're being thorough in our process. My current view is I'm not sure it's necessary as long as the property itself, the adjacent or adjoining property, is covered by damage.
Yeah, but I'm reflecting on the question that I asked of the previous witnesses that, so the house next to me is being rebuilt by a developer and they get coverage under the law, which protects my house from damage. My house is damaged. I'm going to have to make a claim against him. So I'm going to be in an adversarial posture. It's a little different than if the contractor, I'm not quite sure how I want to describe this, but if some damage that arises in the property next to me, it's that property. You know what I'm saying? There's somewhat of an adversarial relationship if it's me versus the developer next door.
I think what we need to do is to have a sit down with Mr. Glassick and his organization, with DISB, perhaps with insurance companies, and see how we can address this. I'm not sure I can answer fully today.
Okay, and you're going to do that over the next couple months
Yes.
so that we can move on this in
Yes, sir.
September, October?
Absolutely.
There was also testimony, and not the first time today, about the neighbor notification program. You heard that testimony. Can you speak to that?
Yes, I can. And if we need to get into any granularity, I may ask our chief building official to opine. First of all, the neighbor notification process actually emanates from the Construction Codes Coordinating Board, which is independent of DOB. We do play a role in it. We are represented on it, but it is an independent board. And I believe, and Nicole, correct me if I'm wrong, that the neighbor notification process was adjusted through the last CCB cycle prior to DCRA becoming DOB. Is that correct?
That is correct. The change that the witnesses were referring to was a result of the 2017 DC Building Code. That was the change that occurred back in October of 2022. That Mr. Maloff is speaking
Yeah,
here.
and I think the timing made it look like DOB came into being and made it happen, but that's in fact not what happened. One of the primary changes that I think has been discussed since I came on board, frankly, is the period of time with that a neighbor has to respond with appropriate technical objections. The amount of time they have to actually look at plans and details and make an analysis and a response. Right now, it's 10 days after permit issuance. I said last year, I believe, in my confirmation testimony, or rather Q&A, and I've said several times since then, and to Mr. Maloff in a meeting, that we are very open to expanding that period of time to 30 days. It feels appropriate to me. We are committed to making sure that does happen. It is would be a consideration of the current CCCB cycle. But it's something that we're focused on.
I guess I have a couple of questions there. So, all right, this happened before Department of Buildings came into existence. It doesn't change the fact that this is what the current process is. So the CCCB is the one that takes this up.
They would, yes, they would consider neighbor notification.
This is not something that's, you have the authority to do.
I do not believe I have the authority to simply change it.
And when does the CCB, when can they affect this change?
It's actually a relatively, rather than try to recite the schedule to you, I would rather send you the current cycle. It's a fairly detailed process because there's meetings and opportunities for public comment and things of that nature, and it's easier to see it in a graphic form. Nicole, would you like to add anything, or does that cover it?
That does cover it. And just to reiterate, there will be a public comment period when changes are proposed or amendments. So that would be also a great opportunity to have the witnesses to opine on that requirement.
But that could be next year or 2 years from now. It's not like it's this year that the CCCB could make that change. Am I right?
That is correct, but we can get back with you on the actual schedule, which we anticipate it to be sooner than 2 years.
The CCCB can take things up in between their, what do I call it, routine construction code update. Can't they?
Let me get back and speak with my general counsel and see where, if I have the authority to actually issue a bulletin of something of that sort. So if you'll allow. I'll
That
do
would be on your authority. But with regard to CCCB, my question is, isn't there the ability for them to take something up in between the routine construction codes amendment cycle?
I'm not sure there is, Chairman. Yeah, we'll have to confirm.
Okay, so you'll get back to me on that as
Yeah.
well. Help me understand here. So it's the property owner has 10 days after the permit has been issued. So again, my neighbor developer bought the house, gonna like tear down 3 walls and completely reconstruct it with 5 floors. Well, maybe not 5, but 4. I'm making some of this up, but so they get the permit and then I get the notification and then I have 10 days.
It's actually slightly different, actually significantly different. There is a notification that a permit is pending that happens, I think, 30 days in advance of the issuance. There's currently 10 days for a neighbor to provide technical objections to the proposed work. And that's the period of time, that 10 that we're proposing be changed back to 30 days. Nicole, do you want to walk us through the sequence from A to B, A to Z?
So the neighbor notification process starts when an applicant submits the application. They're required to post a public filing notice on their property. This informs the public that this is what the scope of work is, that they're intending to file and pursue this application. At that time, when the application is submitted, if the scope of work does in fact require neighbor notification, it is triggered during our intake review. When that neighbor notification review is triggered in our review process, it also allows for all plan documents that have been submitted by the applicant to be made public in our e-record system so that the neighbor, the adjoining and impacted neighbor, I will say, has access to review those documents. Even as the documents change through the review process, the neighbor has access to review those documents prior to approval. And once the permit is issued At that point, they have 10 days to provide technical objections that have to have merit and can be reviewed by their structural engineer or whomever they may deem appropriate, and they can send that to us for review and consideration. I do want to mention that at any point, if we receive comments or concerns from a neighboring property, we take those concerns very seriously and we review them alongside our permit application to ensure and as much as possible, eliminate any damage, potential damage.
So I have a two-story deck on the rear of my house. I want to tear it down and put up a new deck. I need a building permit for that?
Yes, that does require a
Okay.
permit.
So to do that, I then have to post a notice on the front of my property that I'm applying for a building permit to replace the deck?
If it does impact the neighboring property, if it's on a property line or if it has any impact to their party wall, it would require public notice and the neighbor notification process.
Okay, so so if it doesn't impact if it's not on the property line, and you tell me, the applicant, that I have to post a notice, if it doesn't impact the neighbor, then I don't have to post that notice in the front of the house. All right, let's go back to the developer. So the developer is going to completely reconstruct the house next door. They get issued the permit. I have 10 days to file technical objections. Are they able to proceed during those 10 days?
Yes.
They are able to proceed.
Interesting. So theoretically, if they're doing underpinning, they could try to do that in the 10 days while I'm trying to get somebody to review. But if you extend it to 30 days, they're able in 30 days to do that work while I'm still reviewing. All right?
Yes.
All right, well, you'll get back on to me with regard to the schedule for the construction codes coordinating board, whether they could take this up on an interim basis, whether you have authority to do something on your own. And you're going to get back verifying how many permits you think are impacted by this this bill.
Yes, sir.
On this bill, one last question. The council approved the permit legislation on December 20th, 2022. The mayor signed the bill into law in January 2023. The executive sent emergency and temporary legislation as well as this bill, Bill 25-654, to the council in January of this year. That's a year after the mayor signed the permanent legislation, the current law, which of course had been pending for a little bit of time. So why did it take over a year for the Department of Buildings or the executive to identify these gaps, these permits that should have been included?
Chairman, it's a similar answer to the one I gave earlier. Shortly after I came on board in May of 23, it was recognized that there were several permit types that we felt should have been included in the bill. And so that's essentially the crux of what caused the delay.
Give me a second. All right, I'm going to turn to the other bill. I have questions for both of you. I'm going to start with this. The Board of Residential and Commercial Contractors. So I can't quite tell because I'm looking at the red line that Ms. Crowe you sent. So I don't know what's in the bills introduced as opposed to the changes, but it proposes 7 members, 2 of whom will be consumer. Doesn't say who will appoint them.
So right now, that's done by MODA for a lot of the other boards. I think we're open to a discussion about appointments. Generally, our comments in the red line are just making it mirror some of the way we handle other occupational and professional licensing, as well as what Maryland and Virginia do with their boards. Theirs are a lot larger, I'll say. In some instances, the composition of the boards are larger. We're recommending 7. We think it's manageable for the district. And while we are recommending 2 sort of non-practitioner members, and we're calling them consumers, we would like to have one of those consumer members be someone who has some subject matter expertise. So whether that's a building official, a licensed contractor, subcontractor, but is not in the practice, someone who may have some inspection background, someone who can provide an impartial view, but also represent consumers. And I don't know, Director Hanlon, if you wanted to add to that, but.
No, I would agree, Director Crowe.
It's a little confusing and maybe you could send us some language.
Sure.
So I'm looking at this paragraph here. 7 members, 1 of whom shall be a construction manager licensed in the district, 2 shall be general contractors licensed in the district with at least 2 years of experience, 2 shall be general contractors licensed in the district with at least 2 years of experience. 1 was with experience in residential property construction or repair, and the other with commercial property construction or repair. And 2 shall be consumer members. So one of those consumer members, it should say shall have experience,
I
but
think
not the experience the others have.
we went back and forth within our agency as well as with the Department of Buildings about that last member. And I think we sent some comments in an email after sending the red line, just saying that last member we're a little bit more flexible on, because looking at the way that Virginia and Maryland have structured their board, there's a building official on their parallel boards. I think it makes sense. I think in this area, and please, Director Hanlon, you're letting me talk about the industry, so please cut across. But there are people who may have been general contractors, but now they're on the inspection side, or they operate as a third party, or they work for the government. And so there'd be a little bit of blur there, but I think the last member, that 7th member, we want to get additional feedback on who should be that.
Yeah, I mean, I didn't mean to leave you hanging there. We think that you just have to have a little bit more thought around the optimal composition of the board. It may include someone from DOB. It may include, someone from the inspection industry or folks like that. We just want to make sure it's composed of the right mix of people so we get the right expertise.
All right, so you'll send some
We'll
suggestions.
send an update.
Inspect if you have quota, they would say with enthusiasm, oh yeah, we can't wait for another board to have to.
And there's a lot of work involved in filling a board and rotating people on and off, but we feel like it's worth it in this instance, the work that's involved.
How does someone become a general contractor in the district under current law? You sort of touched on this, but could you go over it again?
Yes, so for general contractors right now, they follow the same process that most individuals seeking a basic business license would, with sort of an exception that they have to provide 2 sample contracts. We have one example on our website, for instance. They have to do the same things other businesses, like have clean hands. They have to register with our corporations division. they do have to have insurance and provide evidence of that insurance. But it's one of the lower threshold. There are a lot more requirements to be a home improvement contractor than a general contractor.
Um, So we would be setting up these new requirements. Does it, I think I know the answer, but does this in any way what we have in the bill conflict with the BEST Act?
So it does not conflict. So the BEST Act, in combining some of the license types, it eliminates general contractor and instead makes it more general. It's like a construction and construction industry license. So I think one of our comments about the bill later on about just clarifying the license structure applies whether it's right now or after BEST Act implementation. We would need to clarify sort of the requirements of someone who wants to operate a construction business versus the requirements of someone in the industry operating as a contractor. So we don't believe there's a conflict.
Okay, give me just a. Mr. Hanlon, under our current statute, this board would most likely operate under your sister agency, DLCP, but you are tasked with assessing the work of contractors via permit reviews and inspections. How would enforcement against contractors who perform shoddy or illegal work occur when this bill is approved?
Well, first, let me say that it starts with our intake process. And so I mentioned earlier the template, the intake process. We're in the midst of improving that.
This is intake for permits?
Yes, for permit applications and drawings and all that stuff. But we would continue to, enforce compliance as we currently do with construction codes under our current practices, where we're just standard operating procedure. We are, going to sites and inspecting and making sure that the work is being done in conformance with the code. There would be this requirement would exempt, I believe, permits or applications that have occurred prior to the bill becoming enacted.
Well, so let's go to my house again. So the next door, they're completely redeveloping. And either a routine inspection or you get a call from somebody, maybe from me, and you go out and you see that the contractor is just doing like the worst work ever. Now, you could issue a stop work order, but this is a contractor who either A, doesn't have a license to be a general contractor under this new law, or B, has a license but really shouldn't have a license because he's really, really bad. But the board is not under DOB, it's under DLCP. The licensing is not under DOB, it's under DLCP. So help me here. What happened?
Well,
How do you?
Our focus is going to be on conformance with the code, the life safety and health components of the code. Our relationship with DLCP, which is of course very strong, we would continue to work collaboratively with them. If there are quality control issues with a contractor's work that may impact their licensure, we need to collaborate on how we will address that to make sure that, because there's two issues. One is it safe and is it healthy? And then the second set of issues is the work being done in a way that's at a higher level of quality. I actually think that the bill is going to produce the elevation of what it takes to be a general contractor in this city is going to produce it's going to, I think, eliminate shoddy contractors. It's going to help reduce the number of shoddy contractors in the city. So I think the bill itself is going to be helpful in that regard.
Yeah, but I think you're
Okay.
kind of not answering my question.
May I?
Yes.
Please.
I think, so right now for housing, let's say, so you file a housing safety complaint, like you want an inspection. If an inspector goes to the property, it's unsafe, and they look to see that the person renting is also unlicensed, they currently refer those to us. And we're working to automate that, make it a little bit easier. But for instance, now the teams, maybe they'll send a spreadsheet of a bunch of addresses. There are also inspectors who will actually fill out our complaint form, which we really greatly appreciate when they do that. And then we investigate those cases. So similarly here, the expertise of the buildings department would identify if there was a contractor who was doing shoddy work or unlicensed, they would refer it to us, and we would send it through our investigative process. That's how it works now. And the addition of the board, though, would give us greater teeth to do enforcement. We would have similar sort of expertise on the board to evaluate those claims, as well as regulate the profession. So if the person shouldn't have a license, the board would have the power to revoke the license at the recommendation of the buildings department and others.
So the current practice in other areas like housing is that Mr. Hanlon's inspectors would make a referral to DLCP.
If there's an unlicensed, so that's primarily for like unlicensed rentals. And
Sure.
And, it's a process that's being refined. As you know, both agencies are updating our systems and processes, but that is something that I think we have defined as a referral to us.
Well, all right, so I'm thinking unlicensed, but also like completely inept,
So
like doesn't understand basic construction techniques. And that's what Mr. Hanlon's inspectors figure out. They've been out to this property several times. They've issued stop work orders. I mean, the contractor just doesn't get it with regard to erosion or mudslides, I'll put it that way, and faulty construction and so forth. Should never have gotten a license. That's a little different than the residential analogy you're giving. But again, you would expect that Mr. Hanlon's inspectors would make a referral to you.
Yeah, if our inspectors are seeing work that is clearly shoddy and not meeting the standards for stormwater control or things of that nature, yes, we would refer them to DLCP.
Now, should this be addressed in the bill somewhat? So it makes it easier for you to do this?
I think that may be able to be addressed in the rulemaking process. But I'll ask Monique, do you have an opinion?
I don't know that it needs to be in the bill. I agree. It's probably something that can be worked out in a rulemaking in working with DLCP.
Forgive me, I went to
No,
our senior legal counsel. I'll ask you.
I love to listen to lawyers first. So
I'm
I
glad
think
somebody-
we would prefer to be able, for operational things, given all of the change, to do it outside of the bill, only because operationally, like for instance, one of the requirements is providing documents in triplicate right now. That's in the current law. We want to be able to modernize and have some administrative flexibility to change things based
Sure.
on.
But rules require authority in the statute. So
They said rulemaking. I'm hoping for a little bit lighter, but we work well together.
well,
so
I'm
we-
confident that between all of you, you'll take a look at the bill and see whether it would just help to have something added to the bill, tweak, if you will,
Sure.
to make sure you have all the authority that you need.
Thank you.
Need to ask. In addition to licensing requirements, jurisdictions like Virginia and Maryland require general contractors to furnish surety bonds up to a certain amount if they cannot meet financial solvency requirements in the law or regulations. Currently, the district requires surety bonds for contractors working on government projects. Do you think a surety bond requirement should be included in this bill?
So I have an answer as a government official. Director Hanlon probably has a similar answer, but from a practical standpoint, I think it's a gap in our current requirement for general contractors for sure, but we don't want it to be too onerous, so.
That's really the crux for us is, we want to create a balanced approach that doesn't create a threshold for smaller businesses to be able to come in and thrive from a cost perspective. So we have to find that balance between protecting people and also not inhibiting small businesses from being able to operate and thrive. So somewhere in there, there's a solution, and we will find it.
That means that you'll be working on that over the next couple of months.
Well, so that there currently is a requirement for home improvement contractors, like it could mirror that, especially if we're collapsing them. It hasn't proved to be too onerous because they have to get insurance. Anyway, I think the application of that bond process and sort of how we instruct people to file claims or the steps is really where the harder work is going to be.
Yeah, and my experience with this is that on larger projects with larger contractors, they're robust enough that these things are already in play. With the smaller companies, they have issues with access to capital and other items which make these kinds of requirements harder for them to be able to thrive in business. So we just have to think really carefully about how we craft this aspect of it so that we don't harm small business.
Sure, but what's coming to mind is Mommy Preston. Now, you could argue that that contractor should never have gotten a license. Well, actually, they didn't have a license, that they wouldn't get a license, but they were a small contractor and did a lot of damage. So I totally get what you're saying. We don't want to make it impossible to start up a business if you're qualified, but we've got to be able to protect adjacent property owners.
Yes, and in the case of Mommy Preston and certainly Miss Narani and others, the adjacent and adjoining property insurance bill would provide them that protection. That bolstered with elevating what it takes to be a general contractor, those two bills together are actually, I think, a great leap forward.
So both of you will look at this issue.
Yeah.
Now, related to that, Ms. Crowe, in your testimony, you suggested establishing a residential commercial contractor guaranteeing education fund. So that would be another mechanism that consumers could obtain reimbursement for harms.
Yes. And as I understand it, in order to file a claim against the bond, you have to have gone to court. You have to have, there's such a high threshold. Whereas with the board activity and working through our agency's investigative process, there's mediation, there's sort of the threat of your license being revoked, because once your license is revoked, you can't work on other projects, you can't earn money. So it gives additional teeth with a little bit lower of a threshold than typical for a surety bond and others. So we're recommending the fund.
I think I got confused. So one has to go to court for the surety bond?
You
but
have to.
Your
provide-
proposal for the guarantee fund would not require going to court?
It doesn't, no. You don't have to have a court order to file a claim against the funds that we currently have.
And you would recommend this being somewhat like with the real estate, I'm familiar with realtors. I'm not familiar with the Combat Sports Commission.
Yes, they all have funds for that purpose. We also, portion of the funds is used to administer the programs. The boards meet, they hear complaints, people can file claims against the fund if their claim is found to be valid. It's not something that happens often. For instance, the real estate fund only has a couple of claims a year, but it is a protection there for consumers.
And the Realtor Fund is, as I recall, a percentage, it's got to be less than 1% of whatever the sales are.
I don't know what the exact percentage is. I know that there's a threshold that was set by the council for like minimum fund amounts and things like that, but
Yes.
I'll find out what the percentage is.
I'm not sure I care so much because we could figure that out too, but it's like a percent of sales goes to this fund.
Right, a percent goes into the fund, some of the like license funding goes into the general fund, some of it goes, so it's not the full amount that we get from licensing activities.
Sure. And so what would be, have you thought through the details of this to set this up? What would be the fee?
So I have not thought about the fees yet, but we most certainly can.
Because we probably would have to have that in the bill.
And I feel like right now, so the BEST Act, it reduces basic business licensing fees, but it didn't actually touch on occupational and professional licensing fees. So while those are not reduced by the BEST Act, we also haven't really increased them beyond like the inflationary requirement each year. And so we would probably make these mirror those. And I don't know the exact cost of the licenses, but I know the boards and the professional community, they're very vocal about things that they don't like. And we have not heard that much about license costs, right? So I think we would make it mirror what we have in other professions with advice from the buildings department and the committee.
And I did, just to add, I have not heard one peep with regard to cost. I've only heard support from the industry.
Well, sure, but that's probably because nobody said anything to them about cost. So this again is something over the next couple of months that you'll.
Okay. And we did send this bill to the chair of the Board of Industrial Trades because they actually came to us. They want more reciprocity with other states like Maryland and Virginia. And they were fully supportive of this bill and believe that others in the industry will be too.
I think I have a couple more questions. Let me see. So, Ms. Crowe, I was enjoying your testimony until I got to the penultimate paragraph. And you said, it is important to note that implementation of this bill will require that we update our systems and website and hire staff and inform the public. And then I thought, fiscal impact statement. So are you saying that this is going to cost a lot of money for us to implement?
I don't think a lot. I think sometimes because the scope of the authority of DLCP is so broad, they think we're a large agency. We have 198 employees. And so something like this that we fully support, we did initially look at whether or not we could use current staff, but our administrative teams for the boards, everyone has at least 2 boards that they already manage. So we have to really think about the workload associated with this board. I actually believe that once we tell the public about this, it is a board that will get a lot of activity. There is a lot of interest in the board and a lot of support for it. So I would want to make sure that whomever is administering this board, supporting this board, was able to do that as a dedicated role rather than, they're doing this and Barber Cosmetology and Industrial Trades and other boards. We would want it to be focused.
So that would be 1 FTE?
I think 2. So an administrator and then a support staff person. And then in terms of like sort of the executive assistance and things like that, we would share. Like we're not trying to overstaff it, but we would want to make sure that the board had dedicated personnel. And looking at, as some of the other details are fleshed out, the Department of Buildings might feel like someone to receive complaints or the referrals would be important to do triage. So I think we would seek some additional feedback on staffing because we wouldn't want to overpromise and then underdeliver on the administration of the board.
Mr. Hanlon, do you want to add to that?
Well, I think we need to continue to sit down and work through the operationalization of this to identify if we've left anything out with regard to potential fiscal impact. Right now, we're not envisioning any fiscal impact on our side. For us, the primary work in a way with regard to this bill is, I mentioned earlier, the redesign of our project intake and the putting it into a template form so that when applications are coming in, projects are coming in, we're able to quickly ascertain whether or not a contractor has the proper licensure. And if not, then we would refer to DLCP. So that's, for us, a relatively simple process in the beginning. And everything else in terms of how we behave would be, in a way, standard operating procedure. We're continuing to go on site, we're continuing to monitor construction activities to be in conformance with the code, and continue to collaborate with DLCP, hold contractors accountable. I think the bulk of the operational impact is really on the DLCP side.
So, Ms. Crowe, if you could look really hard at this, because 2 FTEs, I'm guessing, is about 1.2 million over the financial plan.
I will look. I will look to see what that is. I don't think we had anticipated that much, but I will look at it. And we will get back to you sooner than a few months from now about the potential cost. And we were thinking that as we do some of our other updates, we would fold this in. So the technical cost would be less than a normal period where we're not doing so much change already. It's mainly in staffing.
Okay, if you would look at that and work with Mr. Stum on the committee, the whole staff. I mean, it sounds like my hope is that we can move forward with this legislation September, October. That means all the stuff you're getting back to us on, or that you're thinking about, you're thinking through over the next month, 2 months maybe. And that then we would adopt the legislation subject to appropriation, which I hate. And then we would have to fund it with the budget next year. And it would be nice if we could fund this without there being a hit, because there'll be a lot of other hits. Let me see if there are any other questions that I have. Councilmember Bonds.
Thank you very kindly, Chairman. I waited very patiently. I appreciate all the dialogue that you've had with our government witnesses, but I just have a few questions. I will not be 53 minutes
It can be as long as you want.
Oh, no, I will not. I will not do that. You've taken a lot of my thunder, but so it be. I do want to inquire about a couple of things. And Ms. Crowe, I especially appreciate your testimony, your very in-depth testimony regarding this board that you're proposing. I really am hoping that we can get past 7 members, maybe to 9. I think it's important to have a few more consumers on the board, and I would especially appreciate if one of the consumers could be an older person, because that is where the rubber hits the road in many instances. They tend to be the owners of property in community, and their properties are I believe, affected rather generously and regularly. So I would make that request of you and I guess to the chairman as your document moves forward. So thank you, though, for being comprehensive about that. I do want to ask about your proposal for this fund and how it would work, the guarantee fund that you're proposing. What I want to know is, what would be the, in your opinion, the criteria that could get a case before this board, this, I guess, this fund, and how would individuals be assured that their situation would entitle them to having access to this fund?
So one thing I will say is that part of the reason that the composition of the board has been such a debate or a discussion, a rigorous discussion, is because this would be a board that has the ability to hear complaints, look at all the facts, and make a determination, right? Not just on the person's license, but on the remedy for the impacted individuals, right? So anyone has the ability to submit a complaint. They would have the ability to submit a complaint, the ability to submit the facts for the board to review and examine. So there's no criteria for being able to submit your matter before the board. But that board, and as part of this effort, and this is where the Department of Buildings and their expertise would really come in handy as far as board administration goes, right? What do we consider shoddy work, right? When has someone's rights been violated? Is it because they're using materials different from what they promised in the contract? Is it because they don't have the right subcontractors on and it resulted in poor quality or incomplete work? So the criteria for getting paid from the fund, I think, requires a lot more detail. The criteria for being able to submit a complaint is broad. Anyone should be able to submit a complaint, as they can now.
All right, and to date, during this FY year of 2024, how many complaints have been filed with your office or with Mr. Hamlin's department?
So, go ahead. You go ahead.
I wouldn't know. We'd have to go back and dig and see how many referrals have been made, but I can't answer right now.
So,
is it possible to get that information any time soon?
Yeah, I think so. I'll have to check with my team, but we will get back certainly within the next 2 weeks to provide you as thorough a response as we can.
Thank you very much. I also wanted to ask a little bit more about this notice process and the way in which a complainant is, or potential complainant, the owner of an adjoining or an adjacent property might move forward if and when their property is damaged. And the whole process of notifying the owner of the adjacent property that construction is, that the owner of the property that is to receive repairs, or the lot that's going to hold a new property, what is that real process that you're using today? If I understood your testimony about 40 minutes ago, you indicated that it's one where the owner gets, or the contractor gets the permit, and then the adjacent property owner will be notified that there is a permit in force. Is that what's going on now?
No, there's a a public notification that occurs about 30 days prior to the issuance of a permit. Our chief building official, Nicole Rogers, is here, and she actually outlined it earlier. I'll ask her to do that in just a moment, but I will also say that you may have heard us say to the chairman that the neighbor notification process, which is tied to the Construction Codes Coordinating Board, which is independent of DOB, it actually enacts neighbor notification. So we will also we're providing to the chairman and to your office the CCCB process. So Nicole, if you don't mind just walking us through the whole process again.
Sure. So there is, for the neighbor notification process, if there is work that impacts the property line or party wall, the applicant is responsible for posting a public notice of the intended work. This is when the application is submitted. When the application is submitted, as part of our intake review, we also have a neighbor notification review task. When that task is triggered and plans are submitted, the neighbor who is impacted by the work has access to review all plan documents that are submitted that are under review. Within that process, the applicant is also required to provide via certified mail notification to the impacted neighbors. It is a form that goes to the impacted neighbors that they can basically see what the scope of work is, whether it's excavation and those details, while also reviewing plan documents within our e-record system. So this occurs while the application is under review, that they have time to review those documents. They can consult with their own design professional as needed. At the point where we have reviewed the application and it's been approved, and we've also done verifications to ensure that proper protections are in place for the neighbor. The neighbor does have 10 business days to provide technical objections based upon their review of the plans and permit.
Okay,
I'll
and
just
I
add-
think
go
I
ahead.
heard that before, and I guess for me, living in the city and having neighbors on both sides of me, and hearing this time and time again from many who are in the same situation, it sounds like we are saying to the public, if you want to protect your property, it's up to you. In other words, someone can be actively pursuing their property. It may affect your property, but the only way you can protect your property is to jump up and down. If you have a walker or you can't get around, you got to figure out how to look on somewhere on the adjacent property that there is something going on. You have to have the know-wherewithal to be in touch with the government and to protest. I really feel that this is a service that does not work for people who tend to be the ones that suffer the most when we have neighborhood construction, particularly residential construction, afforded. I mean, I have sympathy for the construction industry, but I also have sympathy for those residents that are affected. I want us to have everyone who wants to be a business and who can perform to have that option in our city. But we cannot put the onus on the adjacent property owners to protect their property. That really concerns me. So thank you very much. Thank you, Chairman.
Councilmember, that concludes your questions?
Yes, it does. Thank you very much.
Thank you. I appreciate your patience while I was going through my questions, so thank you for that.
Yes, you covered so many of the things that I was concerned about. So I thank you for that dialogue.
Thank you. That's going to conclude. I have no other questions for you all. Last chance, Councilmember Bonds. I'm going to close out this hearing. We have another hearing, I think, scheduled at 1 o'clock on legislation concerning a project with highway plan, building restriction line, nothing to do with you all. Let me just say again, this has been a hearing on two bills, Bill 25-654, protecting adjacent and adjoining property owners from construction damage, and Bill 25-737, General Contractor Licensing Amendment Act of 2024. As I indicated earlier, the record in this matter will close at 5 PM on Thursday, July 25th, 2024. That's not to say that we won't get comments, and the agencies owe us some important information over the next couple months. But in terms of filing the record, that's our deadline. The time is 12:26 PM, and this hearing is adjourned. Yes, we're compiling a very long list. I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Thursday, July 11th, 2024. The time is 1:04 p.m. And we are conducting this hearing in room 412 of the Johnny Wilson Building. This is actually the second of 4 hearings the Committee of the Whole is having today. This hearing is on Bill 25-825, entitled Removal of the Highway Plan and Building Restriction Line from Lot 9 in Square 5914 along the west side of Congress Street Southeast, SO 22-01642, Act of 2024. This legislation was introduced at the request of the mayor on May 20th, 2024. The stated purpose of this bill is to remove the building restriction line from Lot 9 and Square 5914 along the west side of Congress Street Southeast, and to amend the plan of the permanent system of highways, otherwise known as the highway plan, to reduce the width of Congress Street by the same 15-foot distance regulated by the building restriction line. This will allow for the development of a mid-rise mixed-use building with approximately 180 residential units comprising efficiencies 1, 2, and 3-bedroom rental affordable housing units with ground floor accessible commercial and retail space and approximately 43 parking spaces. The applicant for this, I believe, is the government. And the record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Thursday, July 25th, 2024. So anyone who wants to submit comments and wants them included in the record has 2 weeks to do so. We have 3 witnesses. Salim Adolfo, who is ANC Commissioner with ANC 8C, Single Member District 07. I'll call him first. I believe he's not here. And then we have 2 government witnesses, Joseph Snyder, who's the surveyor DC with the Department of Buildings, and Brant Miller, who is manager of Policy and Legislative Affairs Division at the District Department of Transportation. If the 2 of you could come forward and speak to us. Who wants to go first?
Good afternoon, Chairman Mendelson, council members, and staff of the Committee of the Whole. I'm Joe Snyder, surveyor for the District of Columbia at the Department of Buildings. I appear before you today to provide background information on Bill 25-825, removal of the highway plan and building restriction line from Lot 9 and Square 5914 along the west side of Congress Street Southeast, SO number 22-01642, Act of 2024. This bill was introduced by Chairman Phil Mendelson on behalf of the mayor. The purpose of this bill is to remove the building restriction line from Lot 9 and Square 5914 along the west side of Congress Street Southeast, and to amend the plan of the permanent system of highways of the District of Columbia to reduce the width of Congress Street Southeast by the same 15-foot distance regulated by the BRL as shown on the surveyor's plat. Lot 9 and Square 5914 was created by a subdivision in the records of the Office of the Surveyor in Subdivision Book 219, page 112, recorded February 3rd, 2022. Title to the dedication has been determined to be held by the District of Columbia. The applicant for this bill is the Deputy Mayor for Planning and Economic Development. The Office of the Surveyor notified the relevant executive branch agencies and utility companies of this application on March 3rd, 2022. They have no objections to this application. The utility companies were notified of this application on March 3rd, 2022. They have no objections. Pursuant to DC code, the DC Surveyor's Office notified the National Capital Planning Commission of this application on March 3rd, 2022. In a letter dated March 30th, 2023, NCPC staff determined that the proposed project falls under an exception listed in Chapter 8. The project was made available for public review on the NCPC website. No comments were received. Accordingly, staff has determined that this project is exempt from commission review. Pursuant to DC Code Advisory Neighborhood Commission, ANC 8E, was notified of this application on March 3rd, 2022. In a letter dated June 17th, 2022, ANC 8E supports this application. This concludes my testimony. I appreciate the opportunity to appear before you today and welcome any questions you may have regarding this matter.
Thank you, Mr. Snyder. Mr. Miller?
Thank you, Chairman. Good afternoon, Chairman Mendelson, members of the council, staff, and district residents. My name is Brant Miller, and I am the manager of the Policy and Legislative Affairs Division at the District Department of Transportation, commonly referred to as DDOT. I am here today to present testimony on behalf of Mayor Muriel Bowser and DDOT Acting Director Sharon Kirschbaum regarding Bill 250825, the removal of the highway plan and building restriction line from Lot 9 in Square 5914 along the west side of Congress Street Southeast, Surveyor's Order 2201642, Act of 2024. The purpose of this application is to remove the building restriction line, or BRL, from Lot 9 in Square 5914 along the west side of Congress Street Southeast, and to amend the plan of the permanent system of highways of the District of Columbia, or the Highway Plan, to reduce the width of Congress Street Southeast by the same 15-foot distance regulated by the BRL. The removal will allow for the development of a mid-rise, mixed-use building in Southeast Washington, D.C., with approximately 180 residential units comprised of efficiency 1, 2, and 3 building rental affordable housing units, ground floor accessible commercial retail space, and approximately 43 parking spaces. As outlined in the surveyor's order report filed by DDOT with the DC Surveyor on April 11, 2022, and the supplemental report filed on January 18, 2023, DDOT supports the elimination of the BRL on Congress Street Southeast, as well as the accompanying request to extend the BRL eastward on Savannah Street Southeast, which will close the remaining gap left over. DDOT requests a note be added to the plat clarifying that the BRL is being extended within Lot 9. Regarding the elimination of the highway plan line along the west side of Congress Street Southeast, it is DDOT's understanding that this action is intended to clean up the plat and remove the designation from the property that was supposed to occur when lots 9 and 10 were originally recorded. As such, DDOT has no objection to the elimination of the highway plan line from Lot 9. This concludes my testimony. Thank you for allowing me the opportunity to testify before you today. I'm available to answer any questions that you may have.
Thank you. Give me just a second. I'm a little confused by this, and I usually don't like proposals to eliminate building restriction lines. So the first point of confusion is, what does that mean to reduce the width of Savannah Street? And am I wrong? I'm wrong. To reduce the width of Congress. All right, give me a second here. Yes, to reduce the width of Congress Street?
Yeah, I can provide some information on that. Again, this is Joe Snyder. Congress Street is comprised of a width of public space, and I would give it a nominal width, but it's a little bit of an unconventional space through this square. And the full width of the street includes the width of the public space and all extended rights into private space via a building restriction line, or something like a highway plan line, which is kind of a master plan line. When talking to the Attorney General's office, they determined that the width of the street itself, the public space, and the building restriction lines or highway plan lines constitute the full width of the street. And I can only assume that they mean the rights of Congress Street on behalf of the government of the District of Columbia.
Because in the past, not that it happens very often, although I think it was just, we just voted on Fern Street up by the Walter Reed. And there was no reference in the language to changing the width of Fern Street. It was just reducing the building restriction line. But here there's a reference to reducing the width of the street.
Because it still exists on the highway plan, whereas Fern Street, many years ago,
Yes. was
Fern
removed.
Street, the highway plan was actually removed from there.
Yeah. But it exists.
But it does exist.
So,
I-
Mr. Miller, when are we going to update the highway plan?
I can't provide an answer to that right now, but I could
No, don't.
talk to my colleagues about.
You should talk to them, but I think the highway plan exists, but is so out of date. So that's all that refers to by saying reducing the width of Congress Street. It's just that if the width of Congress Street includes the area covered by the building restriction line, then by eliminating the building restriction line, we're reducing the width. And we'll probably have to make that clear in the report.
Yeah,
Um,
that is correct.
Now, why, since building restriction lines generally are not touched, Fern Street was touched because there was a lot of confusion about whether it even existed. But generally, we don't do this. So why is it okay to do it here? Who do I want to ask first? Miller.
So after our public space, our development review, the elimination of the BRL will allow for the building to be constructed closer to the sidewalk, which will maximize the amount of housing that's able to be created by this project.
But with regard to urban design, would this look incongruent with adjacent blocks along Congress Street?
In terms of the size of the building or
In
the
terms
position of the building?
The position of the building.
Well, I can't say definitively, but based on the plat, it looks as though the design of Congress Street is sort of atypical to begin with. So I'm not sure that comparing it to other nearby blocks would be because of the geometry of the street. So I'm not sure if the building as proposed would, for example, be placed further out, but it would still allow for the appropriate amount of transportation needs in the public right of way.
Mr. Snyder?
I was going to defer to either DDOT or DEMPED to answer that. We don't see a conflict with removing the building restriction line or see anything apparent that seems to suggest that it would be inconsistent with the streetscape.
Mr. Snyder, you provided us with this. Can you orient me here?
Sure. On this printout, we should look at it in like landscape mode. And if you look on this, this is where we are, right? Just to the east of this oval shaped field.
To
That's
the east
that-
is to the right.
Yep,
Where it says 0009.
correct. Yeah, and down at the bottom there and then along the west side of Congress Street.
Give me a second. So the road along from left to right along the top is Alabama,
Correct.
and what is the big oval?
I think it's a soccer field or football field.
Yes, but we don't know with whom. And below the oval, the line that's parallel to Alabama is Savannah.
Correct.
And so lot
Chairman.
9
Oh,
is all of this lot from Alabama down to sort of is like a triangle down to Savannah. Correct. Lot 9, which is the lot where the development will occur, is to the right of the oval and to the left of Congress and below Alabama and above Savannah.
that's correct. I'll also point out that lot 10 is, on the map that you're looking at, is Bard High School. I believe the field is a part of the high school.
Okay, that's helpful. And I guess neither of you can really speak about the development. Mr. Snyder, you're striking your head no. Mr. Miller?
No, I would ask to follow up with our colleagues at DEMPED to provide specifics about the development project.
Well, it's good that they came since they're the applicant, right? They're the applicant?
The surveyor's office is not a part of DEMPED.
I understand.
Yeah.
I said it's good that they came.
Ah.
They're the applicant. Okay. Do we have any other questions? So DDOT has no objections.
Correct.
And Mr. Snyder, all the utilities, everyone that you check with, different agencies, there are no objections in the file.
That's correct.
I think I've run out of questions. Good. All right. Anybody wants to supplement their testimony? Not sure how, but if anybody wants to supplement their testimony, got 2 weeks to do so. That's going to conclude this hearing. And thank you all for your testimony. Time is 1:22 p.m. and this hearing is adjourned.